Hi everyone, my name is Dana and I'm here with Dilnia, Jaden, and Rushni. And today we're discussing the landmark case of Canada v. Fontaine. This case, decided by the Supreme Court of Canada in 2017, stands as a pivotal moment in the Canadian legal history surrounding solicitor-client privilege and the rights of individuals involved in legal proceedings. The main focus of this case analysis is the disposition of the records by the independent assessment process, also known as the IAP, within the context of the Indigenous Residential School Settlement Agreement, and whether documents should be destroyed or archived. At its core, this case delves into the intricate balance between the state's investigative powers and the fundamental principles of confidentiality while observing the implications of past solutions on the Indigenous communities and records of their lived experience. This case arose from a dispute over the seizure of documents held by lawyers representing individuals engaged in residential school litigation. This raised profound questions about the extent of privilege protection in such contexts. As we delve into a critical review of this case, we will explore the implications of the court's solution options to destroy the documents or archive them. The reasoning behind this is the broader impact on legal practices, civil liberties, and the administration of justice in Canada. Through a nuanced examination, we aim to unravel the complexities of the seminal case and assess its significance within the framework of Canadian law and society.
So to start off, the problem identified is the disposition of the records by the independent assessment process within the context of the Indigenous Residential Schools Settlement Agreement, and the question at hand was whether the documents should be destroyed or archived. So specifically, the problem is that the Supreme Court's decision in destroying the documents, Canada missed a vital mark on reconciling with Indigenous communities and including their voices in the judicial process. So this highlights Canada's historical treatment of Indigenous peoples and the failure in the Canadian government's obligations in providing Indigenous peoples restitution and fostering reconciliation for its past injustices. So a bit about the background. So this case emerged within the context of the Indigenous Residential School Settlement Agreement, also known as IRSSA. And this is a landmark agreement that was reached in 2006 to address the historical injustices experienced by Indigenous peoples through the residential school system. So the IRSSA aim was to provide compensation to survivors and facilitate the much needed reconciliation between Indigenous communities and the Canadian government. So the decision in Fontaine concerned the disposition of documents that are related to the settlement claims from the historical injustices of Indigenous children from residential schools. So the central issue at hand was whether the documents created by the IAP process should be destroyed or preserved. So one of two key components of the IRSSA was the creation of the independent assessment process, and this provided a mechanism for survivors to seek compensation for the abuse and trauma they endured while attending these Canadian residential schools. As part of this IAP, survivors were invited to share their experiences through the confidential hearings, leading to the generation of sensitive documents such as application forms, medical reports, and hearing transcripts. So the Supreme Court of Canada ultimately dismissed the Attorney General of Canada's appeal. Therefore, the court upheld the decisions issued by the Ontario Superior Court of Justice as well as the Ontario Court of Appeal. This decision was that the documents were to be destroyed following a 15-year retention period. So some interconnected elements regarding the policy and legal background. We have privacy rights, archival practices, remembrance, which includes commemoration and memorialization, and the TRC. So with privacy rights, the confidentiality and privacy of survivors who participated in the IAP were crucial considerations. So these survivors shared deeply personal and traumatic experiences during the process, often with the expectation that their information would be kept confidential. So protecting these privacy rights of the survivors was essential for the court for maintaining trust in the reconciliation process. With archival practices, determining the appropriate disposition of the IEP documents involved navigating complex archival practices and principles. So archiving sensitive materials while respecting the rights, the privacy rights required careful considerations of ethical, legal, and procedural frameworks. So with remembrance, the preservation of records related to the residential school system was essential for commemoration and memorialization efforts. So documenting survivors' experiences and ensuring that these records were accessible for future generations also played a crucial role in acknowledging historical injustices, educating the public, and promoting reconciliation. And then we have TRC, Truth and Reconciliation Commission. So the TRC was established in 2008 as part of the IRSSA to document the history and lasting impacts of residential school system. So the TRC's position in this included gathering testimony from survivors, collecting documents, and promoting public awareness and education about the residential school system. So although I mentioned just 4 elements, this case is not limited to these 4 elements. There are many factors to recognize, such as precedence, accountability, legal interpretation, compensation, the rights of Indigenous peoples, and much more. So we also wanted to touch on the question of precedence in this case, and the TRC did make many recommendations. However, the judges heavily relied on existing laws and precedents instead. This signals that the court made the decision that Canada's legal precedents outshine the significance of these documents. Not only that, but this explains more issues on the failure of Canada to truly recognize and consolidate Indigenous peoples' voices in the Canadian judicial process.
So stakeholders are those who are involved or affected by the case. In the case of Canada versus Fontaine, we have a few. Firstly, the Attorney General represents the Canadian government, focusing on enforcing policies and legal duties. This especially pertains to handling documents from the independent assessment process under the Indigenous Residential Schools Settlement Agreement. They are equipped with legal and financial tools to support or challenge court rulings, but are constrained by public scrutiny and the legal frameworks established by Canadian laws and the settlement agreement. Secondly, survivors of residential schools. Those including individuals like Larry Philip Fontaine seeking healing and compensation for past abuses. They wield the collective power to launch class action lawsuits and engage with the independent assessment process. However, their journey is hindered by the personal aftermath of their experiences and potential resource limitations for lengthy legal battles. Thirdly, entities such as the Presbyterian and Anglican churches in Canada, historically linked with residential schools, aim to address their legal responsibilities, make amends for past wrongs, and preserve their reputations. They utilize organizational and legal support to defend their positions, yet face the risks of financial burdens and reputational harm stemming from legal judgments. Next, the Privacy Commissioner, Information Commissioner, and the Coalition to Preserve Truth champion privacy, information rights, and the preservation of historical records for truth and reconciliation. Their influence is bolstered by regulatory and legal powers, but is naturally limited by their defined roles and jurisdictional boundaries. Lastly, the National Center for Truth and Reconciliation, Assembly of First Nations, Independent Council, Inuit representatives, and the Chief Adjudicator play pivotal roles in recognizing the legacy of residential schools and ensuring justice for survivors. They offer cultural, legal, and community support, yet their efforts can be constrained by funding, political influence, and the legal confines of the settlement agreement and Canadian legislation.
Prior to the ruling of Canada v. Fontaine, two general solutions were provided regarding the storage of the IAP documents, archiving them at the Library and Archives Canada, and its destruction of the documents. The initial solution presented was that the IAP documents be archived at Library and Archives Canada. As stated previously, the mandate of the TRC was to foster truth, reconciliation, and healing with respect to the injustices faced by those Indigenous peoples who face psychological, emotional, and physical abuse at these Indigenous residential schools. A key aspect of the TRC process included the archiving of the documents produced from the IAP procedure. These documents included application forms, medical reports, hearing transcripts, and other sensitive materials. A proposal brought forth by various residential school survivors, Indigenous organizations, and human rights advocates stated that these IAP documents should be archived at Library and Archives Canada to ensure the preservation of these documents as historical records, as they signify a time of great loss and hurt for a large community within Canada. Thus, Canada has an obligation to respect the pain and suffering the Indigenous community went through and should therefore be preserved to commemorate the history of what happened at these residential schools. By preserving the records for future generations, it enables concepts of transparency and accountability in all those involved in the TRC process. However, there were some implications of implementing this solution in the long run. Some individuals that went through the TRC process argued that the process promised them confidentiality and did not want the files to be archived. Therefore, they argued that it could be viewed as a potential invasion of privacy, as these documents contained highly sensitive information that included accounts of abuse and trauma. Furthermore, individuals also argued that archiving the documents could potentially re-traumatize survivors and their families by reliving the painful memories and experiences that they went through at the residential schools. Bubsby highlights that numerous Indigenous organizations stated that IAP records are highly sensitive and their retention would cause distress to individual survivors and create tensions within communities. Phil Fontaine himself opposed the retention of the IAP documents due to this exact same notions. Some individuals expressed concerns of trustworthiness on the Government of Canada, given the history of mistreatment and abuse that they have experienced from the government. Thus, concerns of the government's intentions with respecting to protecting the interests and rights of the survivors was a barrier to archiving the IAP documents. This sentiment is echoed to the Ontario Court of Appeal, as the court stated that survivors should control should control the fate of their own stories, but no one else could keep those stories against their wishes, not even the government. A CBC article also highlighted the retention of the IAP documents. In some cases, the re-traumatization triggered alcohol abuse in some survivors or even suicide.
The second solution discussed was the destruction of documents. Initially, there were discussions about the potential destruction of IAP documents after the completion of the process. This approach was met with resistance from Indigenous organizations, survivors, and human rights advocates, who all argued that destroying the records would erase important evidence of the experiences of survivors and hinder efforts to achieve accountability and reconciliation. As we further explore this option, some advantages were identified from the destruction of IAP documents. These are the protection of solicitor-client privilege. So that's the destruction of documents that could be seen as means to protect the sanctity of solicitor-client privilege, ensuring that confidential communications between lawyers and their clients remain privileged and shielded from disclosure. Preservation of legal ethics. This protects the Indigenous people that spoke out because there would be concerns about the legality or ethical implications of the seizure of documents. Therefore, destruction was viewed as a measure to uphold legal ethics and the duty of lawyers to maintain client confidentiality. Avoidance of unlawful seizure. This destruction of documents may be considered as a preemptive action to prevent potential unlawful seizure by authorities, particularly if there are doubts about the legality of the search or the scope of the documents subject to the seizure. And due to the intense scope of the topic at hand, Indigenous people have already struggled for years to be treated ethically within the Canadian legal system. Therefore, it's crucial to avoid any risk of further harm. However, one of the largest implications of this option is the loss of evidence and the resistance from the Indigenous community. This loss of evidence comes from destroying the documents and results in the loss of valuable material that could be crucial to the resolution of legal proceedings or the pursuit of justice, undermining the integrity of the judicial process and impeding the truth-seeking function of the court. This is a crucial takeaway in providing legal assistance to Indigenous people because destroying the documents can be seen as eradicating their written and lived experience.
Our first solution to the problem at hand includes an initiative known as the Virtual Memorial and Educational Portal, which we also refer to as VMEP. This is an innovative solution involving creating a virtual memorial and education portal distinct from the preservation of individual records, focusing instead on the commemoration and educational aspects while ensuring individual privacy. To better understand VMEP, we've broken it down to 6 main points. Firstly, conceptual framework. At its core, VMEP is an online platform designed to educate the public on the history and impacts of residential schools. It focuses on sharing survivor stories, cultural preservation, and fostering reconciliation efforts. Importantly, VMEP is built on anonymized and aggregated data to inform its content, ensuring no individual records are compromised. Secondly, content creation. VMEP enables survivors to collaborate with artists, historians, and educators. Together, they create anonymized narratives, artworks, and educational modules. The content ranges from digital storytelling and interactive timelines to virtual reality experiences, presenting the history and consequences of residential schools without exposing personal data. Thirdly, survivor participation and consent. Participation in VMEP is entirely voluntary, with clear protocols for consent. Survivors decide how much information to share and it can remain anonymous. They also have the right to withdraw their consent at any time, ensuring that they maintain control over their stories. Fourth, we have educational outreach. VMEP serves as a valuable resource for schools, universities, and public institutions. It offers lessons plans, discussion guides, and interactive elements designed for various educational levels, aiding in the education of the legacy of residential schools. While it can be used by institutions like schools in aid of Indigenous teaching curriculums, it can also be used by those who are not students to further educate themselves on this important part of Canadian and Indigenous history. Next is memorialization, where a key feature of VMEP is a virtual memorial wall where survivors, families, and the public can leave messages, artwork, or symbols in remembrance. This acts as a space for collective healing and acknowledgement. Lastly, access and security. While VMEP is publicly accessible, it adheres to the highest security standards to protect personal data and prevent unauthorized access to vandalism, ensuring a safe space for sharing and learning. In order for me to effectively present the benefits of VMEP, we have gathered some pros and cons of the platform. Firstly, the pros. The portal promotes education and awareness without compromising individual privacy. It empowers survivors by giving them control over their stories. And VMEP serves as a dynamic, accessible tool for reconciliation and commemoration, facilitating ongoing engagement and learning. As for cons, some may seek a more tangible form of memorialization. The development of and maintenance of VMEP could be costly, requiring continuous funding and technical support. There's a risk of underrepresentation if not all survivors are willing to or able to contribute. And finally, ensuring the authenticity and accuracy of the shared content may present challenges. As with any idea, the most important part is taking your plan and putting it to action. Some important notes about the implementation process are that developing VMEP requires collaboration between Indigenous communities, educators, tech developers, and historians. The initial phases will involve consultations and workshops to shape the content and design of the portal. Pilot testing with schools and community groups will refine VMEP before its broader launch, with funding sourced from government grants, private donations, and partnerships.
So our second proposal of a solution was the creation of a specialized Indigenous-led archival institution. The establishment of this would be dedicated to the preservation, management, and access of these records. The solution would address concerns raised by stakeholders while ensuring that the historical significance of the IAP documents are recognized and respected. The solution would be implemented through a 5-step process. Firstly, being governed and managed by Indigenous people ensures that the handling of the IAP documents are made by those who deeply understand the cultural protocols, values, and perspectives. This would prioritize Indigenous self-determination and sovereignty in the management of sensitive historical records outlining years of abuse faced by those in the Indigenous community. Second, its establishment would implement culturally sensitive protocols and practices for the handling, storage, and access of IAP documents while respecting the privacy, dignity, and autonomy of survivors and their families. In turn, This depicts what the Indigenous community first wanted when the retention of these documents was discussed at the TRC. This could be fulfilled by engaging in conversation with Indigenous knowledge holders and elders to ensure that traditional protocols are followed while managing these records. Third, the existence of the institution would require and involve immense community engagement and consultation with survivors, Indigenous organizations, and relevant stakeholders to ensure fair and concise input on the governance structures, policies, and procedures. This would ensure that the institution is run on the appropriate needs, priorities, and aspirations of Indigenous communities. Fourth, the organization would have a high focus on transparency, accountability, and accessibility regarding its operation while providing the survivors and the Indigenous community with opportunities to access the IAP documents, while maintaining the privacy and confidentiality of individuals mentioned during the TRC process. Lastly, the institution would invest in capacity building and training programs to empower Indigenous archivists, researchers, and community members to actively participate in the management and stewardship of these records. This would ensure the sustainability of the Indigenous archival institution. Therefore, by creating an Indigenous archival institution, it would facilitate for a culturally appropriate and community-driven approach to address the complexities and sensitivities surrounding the disposition of the IAP records. It would enable Indigenous peoples to control and manage their own historical narratives while contributing to principles outlined in the TRC of reconciliation, healing, and justice for survivors of the Indigenous residential school system.
In conclusion, the case of Canada v. Fontaine marks a pivotal moment in Canadian legal history, particularly concerning solicitor-client privilege and the rights of individuals entangled in legal proceedings. Our analysis has centered on the disposition of records by the Independent Assessment Process, IAPs, within the framework of the Indigenous Residential School Settlement Agreement, which is the IRSSA. This considers whether documents should be destroyed or archived. This case has exposed the delicate balance between the state's investigative powers and the sacred principles of confidentiality, all while considering the resounding effects of past solutions on Indigenous communities and the crucial preservation of their lived experience. Through our critical review, we have scrutinized the court's consideration of solutions, whether to destroy the documents or archive them, examining the rationale behind each option, its pros, its cons, and its far-reaching implications on legal practices, civil liberties, ethics, and the administration of justice in Canada. By unraveling the complexities of the seminal case, we have sought to assess its enduring significance within the intricate tapestry of Canadian law and society, as well as provide two new solutions. Again, my name is Dana, and we're here with me. We have Jaden, Dilnia, and Rushni, and thank you for listening to our presentations. We urge you to take a look at our bibliography for our references. Thank you.